This morning, the Supreme Court is set to hear oral arguments in two cases challenging President Biden's student loan forgiveness plan. The justices will decide if the president's plan will move forward, a ruling that could impact millions of borrowers. Congressional correspondent Stephanie Liebergen is live at the Supreme Court with what we can expect. Good morning, Stephanie.
Hey, Lindsay, good morning. Well, in both cases today, it was the government or the Biden administration that appealed to the Supreme Court, asking them to weigh in. So take a look. Well, first case, Biden versus Nebraska. Now, that is this case where 6 states are suing the Biden administration, trying to block the student loan forgiveness plan from going into effect. They argue that the president is exceeding his authority, exceeding his executive branch authority. And they're also claiming in their lawsuit, they claim that President Biden is just trying to fulfill a campaign promise to help with student debt. A big question that the justices are going to be considering in this case is, do those 6 states have standing? In order to file a lawsuit for anything in the United States, you need to prove that you were the one that was injured or harmed by whatever you're filing a lawsuit against. So do these 6 states have standing to file a lawsuit will be a key issue the justices will need to wrestle with there. Now, the other state, the Department of Education versus Brown, this was a lawsuit filed by 2 individual student loan borrowers, one who did not qualify for relief and one who qualified for $10,000 of relief, not the $20,000 eligible to Pell Grant recipients. Now, those 2 students filed their lawsuit because they believe this student loan debt relief program should have been put up for public comment in the federal government's rules procedures. They should have been able to comment publicly on it, and those students argue that they would have argued and tried to get the government to do a broader eligibility so that they would have been covered by the full amount of the student debt relief. But in both cases, the major question doctrine is something the justices are also going to wrestle with. Previously, the Supreme Court has said a major question must be handled by Congress, so it is out of the authority of the executive branch, of the president, of the Secretary of Education. So that major question doctrine, another thing the justices might be dealing with in these 2 cases. But in both of them, the justices are really considering technical questions. They're not considering a simple go or no go of whether President Biden has the authority to relieve up to $20,000 of student debt. Take a listen to this lawyer explain it a little bit.
It's not whether people should or should not get this $10,000 or $20,000. It's whether a major question like this should be in the domain of the executive branch, the president, or it should be one for Congress. Did Congress in the HEROES Act years and years ago on September 11th say, hey, the president can make these types of decisions, or did they not?
Now, the HEROES Act was passed after 9/11, and it gave the Secretary of Education the authority to make changes to federal student loan debt payments in the case of a national emergency. So in this case, it was the COVID pandemic that was the national emergency that the Biden administration was using to try to relieve these student debt payments. Now, arguments set to start at 10 o'clock this morning. There's definitely some protests and some people gathering behind me to demonstrate in support of the president's student loan relief plan. Arguments scheduled for 2 hours today, but I think we can probably expect them to go for much longer than that.
All right, congressional correspondent Stephanie Liebergen reporting live for us in D.C. Thank you.